Hello everyone, I'm Srivaswamy, the Head of External Relations at the Center for Corporate Law Studies, Institute of Law, Nirma University. Today, we have the honor of having with us Ms. Shivani Sinha ma'am. Ma'am is a partner at Phoenix Legal, and we are honored to have you here with us, ma'am.
Thank you.
Ma'am, to begin with the first question, and could you share what initially drew you to the field of restructuring, insolvency and finance, and what continues to excite you or to get up every day and work towards this entire legal field?
See, I'll answer the second part first. What is exciting about the law is that it's ever evolving, and every day you pick up the newspaper, you read about something or the other related to insolvency, which is somewhere occupying the headline. Now, as dynamic and as evolving a practice area, and being involved with it is very challenging as well as very intellectually satisfying. So that is one reason what drives me every day. The reason why I took it up has to be a mix of choice and chance. Choice because I was, till the time the insolvency law came into picture in India, which is 2015, I was a banking and finance lawyer, practically. And I had done some amount of disputes related to mostly banking sector itself. Now, once the law evolved, what it sort of did was it completed a cycle for me. For a practitioner like me who could see the one side of the story till the time the funding is done, could also now see the other side of the story, that the funding goes bad and it goes into stress and how recoveries are made, and what is the end result of a company which started off as a venture which took loan. So the entire cycle completed with insolvency practice, and as a practitioner, when I looked at the law, I saw a lot of sense in how the insolvency law was devised in India. So that is something which attracted. Reading it got me more interested, and then practicing it and seeing the entire cycle of the practice got me even more involved. So that is how I sort of transitioned from, I won't call it a transition, I would call it branching out from banking and finance lawyer to also an insolvency lawyer.
So it is very intriguing that the sort of evolution that you had was mostly intellect driven, was mostly because you knew one side of the coin, and then
there was a zeal to know the other side as well.
Yes. All right, ma'am. Moving to the second question, how do you manage the high stakes transactions where legal risk, commercial sensitivity and client pressure, all these three factors, they collide?
See, as a corporate lawyer, it's almost like on a daily basis you have to take certain amount of legal risks. And the reason for that is because Indian laws are subject to interpretations. So in a situation, something may be interpreted in a way, in certain other situation, it may be interpreted some other way. So how you see as an individual, as a practitioner, how you see a law applying in a certain situation may vary from time to time, case to case. And that in itself is a risk because you are taking different interpretations at different points of time. So therefore, legal risk is embedded in practice of corporate law, and I believe litigation as well, because the strategies are again subject to interpretation. So that is the risk part. Client sensitivity part is something that you have to, it comes with maturity. You have to know your client, his commercial requirements. Only if you are catering to his requirements that he would see relevance in you. If you are not catering to your client's requirement, if you are just being a lawyer, he may not need you, because you are not doing something which is working for him. So you have to find solution and ways and means to achieve the commercial end that your client is trying to achieve ultimately. So that client commercial requirement / sensitivity is something that you cannot do without. It's something that is paramount, and everything revolves around it, including at times your legal interpretations, if I may say so.
It is significant how you have highlighted that risk is permanent in this in this profession.
It's a high liability, high risk profession. When you sign an opinion, you are responsible for what is written in the opinion. If there's anything that goes wrong, the liability is yours.
I think it scares the listeners a little bit, but
no, it comes with rewards also, which I'm sure you guys are aware of. So anything which is high risk has high rewards also.
Right.
So that goes without it, and it's innate. It's part of the risk is part of the system from A0 level to even senior counsels at Supreme Court level. So we have to live with it and learn to live with it.
Right, ma'am. So, given that now we have established an understanding as to what are the basic structural nuances where this practice is developed, and given your background of this practice, how do you see that this practice is going to evolve in the coming 5 to 10 years? Do you think it's going to grow or be in the stagnant situation, or do you have another point of view?
See, insolvency as a practice is very cyclical. So there is a cycle where a lot of funding happens, and then the funding leads to stress in the system. So a cycle where funding is predominant, the insolvencies are less. The cycle where insolvency is predominant, the funding is less. So we have just crossed a cycle which was dominated by insolvency. So I see a few years, 2-3 years of the cycle where the funding is going to be predominant. Having said that, the IBC is here to stay, and the IBC cases will keep on going parallelly, just that the intensity and the amount of cases that are going in on the IBC side would be much lower compared to last 5 years, is what my sense is in general. As far as the practice is concerned, it's time IBC also self-introspects. The founders of IBC, the framers of IBC introspect and see if there are a new generation of reforms required in IBC, and which would be relevant, because if you have to keep evolving and keep bettering those points that we have observed are pain points in IBC, then in order to overcome those pain points, we have to evolve the law. And two of the things which are very, very crucially visible to anyone who has had IBC related interaction or has been a stakeholder is the fact that, one, that it is taking more time than what is envisaged in the law, and secondly, there are too many litigations which are being filed in tribunals and they are clogging the entire system. So in order to reduce the number of litigations and in order to reduce the number of days that has been taken to resolve a company, these are the two goals with which the policymakers and regulators should look at the third generation or second generation of reforms for IBC.
So, ma'am, your take on this entire evolution of IBC laws and the practice associated with it, it is intellectually satisfying, if I should put it. But since you have worked on financing structures involving ECBs, ODI and cross-border deals, which type of transactions out of these, or any 4 transactions as well, which is the most type of intellectually satisfying transaction for you? Which one do you find the most intellectually satisfying?
See, on the funding side, it really depends. The more the complexity or the more the newness in structure is where your intellect gets, tapped the most. So therefore, plain vanilla transaction everyone can do. Once you guys are 2-3 years into profession, you will be able to handle the deal because it will be so vanilla in nature. It will be of a certain kind that you would have seen twice or thrice or 4 times in other deals. So doing a deal which has been oft done, oft repeated is not fun. Doing a deal which has some newness to it, doing a deal which is somewhere trying to push the boundaries with regulations is where all the intellectual juice lies, essentially. So those are the fun deals. ECB deals, again, unless there is some new structure, is pretty much the same way it has been since forever. Certain regulations do change and certain things do change as such, but in terms of structures, there are those structures which have been there in the market. Same is the case with ODI, but they have what is interesting per se is, under the ECB regime, they have allowed ECBs for the resolution applicants in IBC also. So you can take an ECB funding and use that funding to resolve the companies which are in insolvency. So those deals I mean, we are yet to see many of them, but some of them which are there in the market are turning out to be interesting. And funding from behind, funding the resolution applicants through various structure from behind in order to resolve a company, all of that is something that is coming with a lot of structuring and a lot of to and fro understanding of IBC law. So those are very interesting structure. So a mix of ECB plus IBC process with a lot of structuring involved is where a lot of interest could be when it comes to ECB.
So ma'am, given your this technical understanding of the mix-up and the entire structuring, I think to sum it up, when there's a novelty involved, when there's something intellectually challenging, I think that's what makes the practice intellectually satisfying as well.
Yes, 10 years down the line, you will also say the same thing.
Okay, I hope to. Well, so ma'am, coming to technical question, how do court-approved amalgamations differ from out-of-court financial restructuring when it comes to legal strategy?
See, court-approved amalgamations are, to start with, they have to have the commercial viability, and then rest of the process is just a process that you have to follow, with NCLT being the authority, or at times if it is a government company then MCA being the authority to approve your the amalgamation, the 232 schemes, etc. So now those are the kind of things which are very, very process driven, very little scope for maneuvering. But at the level of strategizing, in terms of timing, in terms of how, what is the purpose of amalgamating two companies, whether it is stress resolution, whether it is just strategic corporate restructuring, all that is something that may prove to be interesting at the due diligence and at the strategy stage. The second one is court approved and?
Yes. Out of court financial restructuring and
financial restructuring. See, financial restructuring is very RBI regulated. So the adherence to RBI regulation is where the challenge is, because reading the regulations is one part, practically making it applicable is another part. I was mentioning in the conclave also that as simple a thing as intercreditor arrangement to get into financial restructuring at RBI regulation level is something which is very, very difficult to achieve in most cases. So at the threshold itself, what you need to do to do financial restructuring, that itself is difficult to achieve, and that is why the easier option that people choose is either sell off the loans to ARCs or people go for IBC.
Right, ma'am. That was quite informative. And now moving towards our last set of questions, I think this is the part that most of our listeners will look up to. Like, what are some qualities in an intern or in an associate that you think that are very important for the practice, that are very important so that they can develop into an even better practitioner?
See, just one. The person has to believe that hard work is the way of life. That's it. If you work hard, there is nothing else which will inhibit you to succeed. You may not get immediate success. You may not be able to become a superstar in 6 months' time, 3 months' time, 1 year's time. But eventually you will learn the practice, you will learn your basics, you will become a better lawyer, and you will do really well if you are hardworking. If you try becoming a little over smart here and there, try for shortcuts, go for methods which are not work related, then you may be successful, but your growth may not be as steady and as permanent as it may seem.
Right, ma'am. So an additional question, that do you think which approach is better? Should one person develop a niche of a single practice area and then practice the same rigorously, or do you think a person should be generalist and should cater to 2-3 practice areas? Which one, in your opinion, is a more suitable form and a more sustainable form of practice in the longer run?
Very, very good question. As a junior, you may not, when you step into the law firm, you may not be sure about what you are doing. If you are sure about it, go with it. It's an era of specialization. People pay you for specialization. People don't pay you for generic advice. They pay you because you are a specialist. You are giving them market trusted best advice. Now, as far as if you don't know, then you should rotate in first 2 years in different teams. I think there are law firms which have rotation policy for first and second year rights, where they can go to different teams for 6 months, work there, check whether they are liking the work, and whichever one they like the most they pick, and vice versa. The team also has to like the associate. So that is the way to go about it. If you have interned and you have figured out which practice, then continue with that practice till you become an expert at it. After becoming an expert in one thing, do diversify to other stuff, because if you have to become a bigger lawyer, practice area heads, head of the law firm, etc., those things which come after 40 and after 50, those people have an overview of everything. They know businesses, they know all the laws, which can be critical for the business. That's how they become trusted business / legal partners for the businesses, and that is what takes them to those higher levels of being the top corporate lawyers. So start off with specialization, become a partner, after that experiment.
So ma'am, if I put your advice into some other words, would this be right that we can start off with a specialization, but then with time we should also develop some sort of commercial awareness, and that's what makes you valuable as a person?
Absolutely. Just knowing the law is the beginning of a lawyer's life. Knowing the law, knowing the commercials, knowing what the client needs and what commercials and the legal advice together will fetch the client is what will make you a complete lawyer, and what will get you to partnership as well. Otherwise, if you are just a lawyer, it is very difficult for you to then retain clients, interact with clients, retain clients, make more relationships with client. It becomes very difficult. So if you're not doing all of this, you would find it difficult to make it to partnership. If you are commercially as savvy as you are legally, you will someday reach the partnership level, and once you reach the partnership level, after that sky is the limit. Expand your practice, your horizons as a lawyer, as a practitioner, and go wherever you want, as much as your firm allows you.
Thank you so much for this podcast, ma'am.
Yes.
Thank you so much for coming to the institute.
Yes. But don't try and do that when you are a senior associate. Okay. You will not learn this, you will not learn that also, you will be in somewhere in the middle. First, develop an expertise in one practice and then diversify. Don't diversify before that. So there is a level. There's a level that you know that now I am comfortable with this practice area, so I should look at other broader things. Maybe I can do this as well. Maybe I can, as an ancillary practice, do this as well. Maybe do disputes also. Do that when you are into partnership, not before that. Okay.
Understood, ma'am. Thank you so much for this podcast.
Yes,
thank you so much for coming to the institute.
My pleasure. Yes,
and
thank you.
With that, we conclude this episode of Corporate Law Unfiltered. Thank you so much, everybody, for listening.
Thank you.